Sir, it's Aiwa. This outside is okay, sir.
Yes. Hello. Look, please, you cannot block the entrance. They are not blocking. Don't worry. That's what we are ready.
Oh yeah, let's do this thing. Mo mọ̀ pé Táíwò náà ni. Create space then. Can we do this, please?
Hello?
Alright. You look at the camera. Don't look at the...
Which of the cameras am I looking at?
Just look straight. So, can we go?
Yes.
Your name, sir? Your name?
Yes, my name is Oladayo Ogungbe.
Okay. What's the situation?
Oh, okay, so we came to court today. The matter was originally adjourned for the hearing of our motion that we had filed. So the basis of the motion was that the court had made an earlier order where 3 laboratories were approved, 1 pick from us, 1 pick from the respondents, and 1 that was submitted by the welfare officer. Only for us to discover that the 1 picked by the welfare officer don't have the capacity to do tissue-based DNA. In fact, they are cancer research center. We filed an affidavit of facts to this effect. We exhibited emails where the center chosen by the welfare officer came back to us and said they don't even do DNA at all. They are merely cancer research center. And the 1 picked by the respondent, we have an email from the same laboratory saying they don't have the capacity to do tissue-based DNA, particularly if the body has already been embalmed. So in view of this, and the 1 picked by the applicants, that's my client, we had already obtained form. We've been in constant communication with them. In fact, I have sent some of those things to the welfare officer for coordination, because it is not for me to coordinate it. It is for the officer of the control, the welfare officer, to do the coordination. But when we discover all of these lapses and all of that, so we felt, okay, since the order is still subsisting, there is need for us to bring a fresh application. So the application we have brought is now predicated on the earlier order. You know, now, having filed an affidavit of fact discrediting the 1 picked by the respondent and the welfare officer, and there is still one standing, which is the DNA Diagnosis Center in the United States. So we brought an application for court to give effect to that. Let the court conduct DNA using the one that has already been approved. Everybody has the knowledge. We know that they have the capacity. And the moment we file the application is no different from the order that is still subsisting. It is still the same order. But curiously, they found a counter affidavit that no, the court should not permit us to do the DNA using the DNA diagnosis center. They don't want that. So what they are opting for is they want a DNA that will be chosen by the court. We don't have a problem with it, but it will not be disclosed. So they want an undisclosed DNA that will be chosen by the court. The venue will not be known. The name of the DNA laboratory will not be known. The only thing that will be known is that they've submitted, the DNA has been chosen, we submit, the sample has been taken, because you do an undisclosed DNA, will just come with the results. That is the standard practice, but with this Mohbad DNA issue, it is peculiar. Peculiar in what sense? We have a better history of manipulation at the coroner inquest, where the post-mortem pathology, the result for the cause of death came back inconclusive. Even the purported NMS that the Lagos State officials, whoever did it, said the family wrote to that laboratory, and they said they never received any sample that bears that of Mohbad, that they didn't do that. So, and the result came back inconclusive. It was a boy who died and was a and he said because he has behaved, everybody knows that you can even determine the cause of death of a deceased person who has passed on for the last 20 years. So that is where we are. So our own position is very simple. We want a transparent DNA. We want a DNA where we can interrogate the capacity of the lab. It is not just an ordinary DNA, it is a tissue-based DNA. It is a tissue-based in what sense? We can only use his teeth, his nail, or his bone, because there is no fluid in it. So not just to your regular DNA, and only few laboratories overseas have that capacity. So that's what we have. So the case now has been, so there are lapses in, we found a further affidavit, the counter affidavit, and the plan point of view. So we discovered some lapses with respect to the whole thing. So we informed the court that there is need for us to do the correction, and the court agreed with us. And so the matter has been adjourned to 11th of August 2026. Then, so apparently we found another motion, another case. So, in the course of our conduct, in the course of our research, we discovered that there is another sister case being filed by the Ministry. Apparently, she had sued the Ministry of Youth and Social Development and Chief Medical Officer, Military Hospital, Yaba. We were never aware of this case. We were never sent. Only for us to discover that an order had been granted, giving the leave of court to do DNA by the same magistrate. These developments strike at the root of jurisdiction. It amazes me as a person because we're never aware until when we discover we applied for the CTC, we got in the court processes, we got the order that was obtained. Apparently this matter was filed, I think, October last year. Why we are still in the same court for the same DNA. And the question I ask as a lawyer is that why will a mother file an action demanding for the DNA of her own son? The Lagos State Ministry of Youth and Development never demanded for DNA. The Chief Medical Officer never demanded for DNA. It is the Aloba family that demanded for DNA. And from the process we saw that the process is reading the matter of paternity test of Master Liam Aloba for and on behalf of the family of Mr. Ibeoluwa Aloba disease, represented by his father, Mr. Joseph Aloba. this is what was found. But Mr. Oliver was never served. He was never joined in the case. The two parties in this case were Ministry of Youth and Chief Medical Officer. And the question I ask is that the Ministry of Youth and Chief Medical Officer, Military Hospital hereby demand for DNA. So, if the Aloba family is demanding for DNA, it's because you are saying that boy belongs to the Alobas. That is why they are demanding for DNA, which is rightly so. And the basis for this DNA was very simple. The evidence at the coroner inquest that was given by Prime Board and Spendis was very clear. They said the last fight or the last misunderstanding they both had was that Mohbad was questioning the paternity of that boy. It was CTC. It was online. In fact, we applied for the certified true copy. It was on that basis the Aloba said, okay, to clear all doubt as to the cause of death, let us confirm if indeed this Liam, the boy is innocent, but this Liam is indeed Aloba. It will form as a respite. That is why they brought the application for DNA, and we've been on it for years. Only for you to now find another action demanding for DNA. That means the Aloba family were no wrong after all. For them to be demanding for DNA, because if a mother is filing an action to do the DNA of her own son, that leaves no should be desire. I won't say more than that, but in reaction to that, the moment we discovered that, we have filed an application, the notice of prior objection, because we consider that action an abuse of the judicial process. And we have filed the necessary application, and the order that was granted, in fact, the order was granted on the 5th day of May, 2026, we were not aware. We filed an action, we filed a motion for the court to set it aside. Because there cannot be a parallel proceedings in the same DNA. It is unheard of. So that is the position. So for this one, we will pursue for a date. Because according to them, they say the matter has been concluded. Because the matter has been concluded, and there is a subsisting order. But why is the next line of action? No, of course. My name is Malaka. Thank you. I've concluded in this thing.
Yeah, thank you very much. Be a father. Hold on, sir. Be a father representing.
Hold on, sir.
Yeah, be a father representing another family. This DNA is a must. I'm saying this to the whole world for the assistance, because I'm very happy by seeing a lot of people have interest in this case, because this DNA is beyond ordinary paternity. We are tracing the death of Mohbad, reach that level. So it's beyond to know the paternity of Liam alone, because the death of Mohbad is not natural. So as a father, I'm still saying this DNA is the most important thing that delaying the burial of Mohbad. It's a younger, only a job as a Yoruba. That is what made me to bury him in the first time. But when I now assume, a lot of things have been revealed to me. So we need to do the DNA before burying Mohbad. The body is an evidence. Thank you very much.
So why stopping the DNA, sir?
The DNA, we are still on it. We are still proceeding on it. Jumping from one place to another. So we are still on it.
I'm sorry again. Those there were lapses in one of the process that was so we needed to correct it. So the matter was adjourned to 11th of August for the hearing of our own motion to give us leave to do DNA in an already laboratory by the same court. By the same court. So that is the situation. But before they counter-further to it, saying yes, they will found a counter-affidavit, but they don't want us to do the DNA. So we have found a further affidavit and the reply point of it. So that is what the matter is going to talk about the hearing. Then we discover another thing. We have done the reporting to see more than that.
Why did you ask you not to go on hearing?
No, she okay, so they want, okay, so let me just break it down. They want the court to do a DNA, no, to pick a center that will not be disclosed to any of the parties. They just want the court to take the sample. And we are saying, because of the checker history of this case, we are not comfortable. One, we are not comfortable because the welfare officer had earlier submitted a DNA laboratory to the court. When we now sent an email to that DNA laboratory to confirm their capacity, whether they can indeed do tissue-based DNA, the response they gave us is that they are cancer research center, not a DNA center. They don't even do anything close. So it is in view of this, we feel that it is better for the court to approve a disclosed DNA to promote transparency. Everything the Aloba has been demanding for is a transparent DNA laboratory, nothing more. We don't want the undisclosed is the standard practice, but with the case of this Mohbad, it's a peculiar one. It's peculiar in the sense that there is public distrust, and whatever result that is coming must be treated with circumspect. So we are saying with circumspection. So we are saying that for us to be comfortable with this DNA, disclose it. Let us know. In fact, I as a person, my office will write an email to whichever laboratory to confirm their capacity that indeed they can do tissue based, because it's not your regular DNA. So that is why we are here. Only for us to discover that we had filed a parallel suit. She had filed a parallel action in October demanding for DNA of her own son, suing Lagos State Ministry of Youth and the Chief Medical Officer of Yaba without joining the Alobas. So the question I am asking is that is the Ministry of Youth and the Chief Medical Officer, they the one demanding for DNA? This boy is bearing Aloba. The only people that have the right to demand for DNA is their lovers. We are saying it is their son. So Lagos State Ministry of Youth are not saying it is our son or Chief Medical Officer. So for a mother to file an action to demand for the DNA of her own son leaves much to be desired.
Your name, sir?
My name is Ola Daniel.
Let me know that.
Just we are watching this kind of something on the phone, not in real life, but they have happened to me now. So that's why I'm crying to the whole world. Come and rescue me from this, because it is my right to do the DNA, and it's under months. The DNA must be done. Thank you.
Is that?
No, these the people that came.
Okay. Yeah. Elle est sur l'aide. Ah.
Ayọ̀ láti dídé fún àbátúwé kéésì ní ìdájọ́ ìlú.